to Chapter 6 of the PPSA, and here we will play a game. This is the Enforcement of Security Interest game. Great! Now that you have signed in, let's know what you're in for. Your goal is at the end of this game, you will be able to learn how to enforce security interest. What are the two types of processes for the enforcement of security interest, and the options to dispose or retain the collateral. Great! You have acquired an avatar. Remember, you are player 1, and like life, the enforcement game needs to be played for the right reasons. Have acquired a caddy. The caddy will help you get through this journey. They will assist you in learning what stage you're in, and also in getting the codal provisions necessary for you to progress to the next level. Great! You have unlocked the agenda. Here, we will take on 4 stages to complete the game. Before you go out and get your collateral or exercise your security interest as a creditor, first, we have to know what are the rights provided under Chapter 6 of the PPSA. Afterwards, we go on to the next level, which is to take the possession of the collateral. Then, we will get to know how to dispose the collateral on the 3rd level. The 4th and final level, we will get to know the retention of the collateral. Are you ready? Welcome to the 1st level, rights under Chapter 6 of the PPSA. Chapter 6 of the PPSA tells us all about the enforcement of security, interest, and the secured creditor's rights. Other than that, it also provides for the right of redemption. Click on the right of redemption to know more. The right of redemption is provided under Section 45 of the PPSA. It provides that any person who is entitled to receive a notification of disposition in accordance with this chapter is entitled to redeem the collateral by paying or otherwise performing the secured obligation in full, including the reasonable cost of enforcement. The right of redemption may be exercised unless 1. The person entitled to redeem has not, after the default, waived in writing the right to redeem. 2. The collateral is sold or otherwise disposed of, acquired, or collected by the secured creditor or until the conclusion of an agreement by the secured creditor for that purpose. And 3. The secured creditor has retained the collateral.
The secured creditor shall notify number 1, the grantor, number 2, any other secured creditor or lien holder who, 5 days before the date notification is sent to the grantor, held a security interest or lien in the collateral that was perfected by registration, and 3, any other from whom the secured creditor received notifications of a claim of an interest in the collateral if the notification was received before the secured creditor gave notification of the proposed disposition of the grantor.
Disposition of collateral after default. A secured creditor may, upon prior notice to the grantor, other secured creditors, and any other person from whom the secured creditor received notification of a claim of interest in the collateral, sell or otherwise dispose of the collateral publicly or privately in its present condition or following any commercial reasonable preparation or processing. A disposition is commercially reasonable if the secured creditor disposes of the collateral in conformity with commercial practices among dealers in the type of property. The specific guidelines on private or public disposition are set out in Section 7.09 of the PPSA rules.
Section 49. Right to dispose of collateral. Paragraph A states that After default, a secured creditor may sell or otherwise dispose of the collateral publicly or privately in its present condition or following any commercially reasonable preparation or processing. Paragraph B states that the secured creditor may buy the collateral at any public disposition or at a private disposition, but only if the collateral is of a kind that is customarily sold on a recognized market or the subject of widely distributed standard price quotations.
Awesome! We have progressed to the second level. We now learn how to take possession. Excuse the chickens. We now learn how to take possession of the collateral. Well, imagine when a debtor has not paid the amount due to you. Will you go right away to take out his car, his motorcycle, or whatever it is that was made as a collateral? The answer is no. This is where we get to learn the proper procedure to take possession of the collateral. Always remember that there are two processes in taking out a collateral: judicial and extrajudicial. To best understand when these two processes apply, it is best to imagine two scenarios. One is when the collateral is with the creditor. Two, when the collateral is not with the creditor. Let's proceed in the assumption that the debt is already defaulted and the collateral is with the creditor. Under the extrajudicial process, the secured creditor can simply sell the secured assets through public or private disposition, which is provided for under Section 49, or retain the collateral, which is provided for under Section 54. There are also special cases where extrajudicial process applies other than the two already mentioned.
Under the following cases, upon default, the secured creditor may take possession of the collateral without judicial process by, number 1, instructing the account debtor of an accounts receivable to make payment to the secured creditor and apply such payment to the satisfaction of the obligation secured by the security interest after deducting the secured creditor's reasonable collection expenses. Number 2, in a negotiable document where the security interest is perfected by possession, proceeding as to the negotiable document or goods covered by the negotiable document.
On to our second scenario, where the collateral is not with the creditor. There will still be an extrajudicial process if the security agreement so stipulates, but the possession must be without breach of peace. What do you mean by breach of the peace? Breach of the peace happens when entering the private residence of the grantor is done so without permission. It also includes resorting to physical violence or intimidation and being accompanied by a law enforcement officer when taking possession or confronting the grantor. If any of these have to happen or happens, then we cannot perform extrajudicial process. In case of breach of peace, we proceed to judicial process. To initiate the judicial process, we start by applying with the court for an order granting the secured creditor possession of the collateral. The secured creditor will be entitled to an expedited hearing. On his part, the secured creditor must provide the debtor, grantor, and if the collateral is a fixture, any real estate mortgagee, a copy of the application with supporting documents and evidence. The court will try to assess if a default has occurred under the security agreement and if the secured creditor has a right to take possession of the collateral. If the answer to both questions would be yes, then the secured creditor is entitled to an order granting possession of the collateral.
Disposition of collateral after default. A secured creditor may, upon prior notice to the grantor, other secured creditors, and any other person from whom the secured creditor received notification of a claim of interest in the collateral, sell or otherwise dispose of the collateral publicly or privately in its present condition or following any commercial reasonable preparation or processing. A disposition is commercially reasonable if the secured creditor disposes of the collateral in conformity with commercial practices among dealers in the type of property. The specific guidelines on private or public disposition are set out in Section 7.09 of the PPSA rules.
Great, you've made it to the final round. Click the retention of collateral stage to proceed.
Retention of collateral. After default, a secured creditor may also propose to the debtor and grantor to take all or part of the collateral in total or partial to satisfaction of the secured obligation by sending a proposal to the grantor, other secured creditors, and any other person from whom the secured creditor received notification of a claim. The secured creditor may retain the collateral in case of a proposal of the acquisition of the collateral in full satisfaction of the secured obligation without objection from any of the addresses of the proposal, or a proposal of the acquisition of the collateral in partial satisfaction of the secured obligation, but only if the secured creditor received the written affirmative consent of the addresses of the proposal.
You made it! Congratulations! You can now go on and enforce your secured interest.